Thank you, Dave, and thanks to everybody for coming out tonight. I think we have an informative program. As Dave mentioned, the Supreme Court has been very active in IP cases this year, unusually active. We've got 4 in the trademark, copyright, and false ad case. And one of the cases that I'm going to talk about is the copyright case, the Aereo case. Before I get into what the court did, we need to just briefly explain the facts. We're not going to get into too much detail, but it helps to know the technology involved because that played a big part in this court's decision. First, Aereo's business model was very simple and very lucrative. There were a series of steps that somebody could take to get an internet-based program streamed to them on their tablet, smartphone, and so on. The first thing they had to do was identify a show that they wanted to watch that was currently being broadcast. So let's say by CBS, say, this is a show I want to broadcast. They go to their website and they click on it. That's the first act, and I want to emphasize the word act, by a subscriber. That's the first step. The second step now moves to Aereo. What does Aereo do? Aereo takes one of its antennas that now becomes assigned to that particular subscriber. So antenna subscriber 1-to-1. Nobody else gets that antenna, and it's assigned to that subscriber for the duration of the show. Aereo tunes the antenna to the over-the-air broadcast that the subscriber has selected, and then Aereo receives the broadcast on its antenna. Then Aereo's software translates the broadcast into data that it can transmit over the internet. Okay, so that's kind of step 2. And before we think about antennas the way my generation thinks of antennas, these massive structures, this is what the antenna looked like. So you can see the business model. The costs are very, very low to get these antennas. There are literally millions upon millions of them that can be housed in very, very small areas. Okay, as long as they're cooled, they're going to make a lot of money. Okay, the next step is after the signal is received, Aereo saves that data to a subscriber-specific folder. And you can hear the theme here. Everything's very specific with Aereo's business model. And they save it to their hard drive. This is a personal copy, Aereo says. It's not publicly available. It's a personal copy to the particular subscriber. And Aereo is not automatically transmitting it to the subscriber. Right now, it's just saved. Okay? Then the next step is several seconds after it, Aereo's server starts streaming it to the subscriber, okay? So that the subscriber can watch it on any internet-based device, a PC, tablet, smartphone. And the streaming is not contemporaneous, but as the majority says, it takes place a mere few seconds behind the over-the-air broadcast. Okay, so those are the facts that we're dealing with. And for those of you that need a visual, this is really what's happening. Starting from left to right, the broadcast signal comes out from CBS. It's picked up by the antenna, it gets saved to the hard drive, and then it gets transmitted down to the smartphone or tablet or what have you. It's very simple. Okay. What happens? The plaintiffs get upset. Who are the plaintiffs? The plaintiffs are broadcasters and TV producers and others who own copyrights, and they say, look, you're violating our copyrights. So they bring a lawsuit, and they use a couple provisions of the Copyright Act. One is 106, which has what's called the bundle of rights for copyright. One of those bundles is it gives copyright owners the exclusive right to perform a copyrighted work publicly. And then the transmit clause, which kind of gives a little added definition of what perform means. The transmit clause says this exclusive right to perform includes the right to transmit the copyrighted work to the public by means of any device or process, regardless of where the members are or when they see it. So these are the 2 provisions at play. And importantly, we'll hear, because Justice Scalia jumps on this allegation that the court is addressing is direct infringement. It's not secondary liability, it's direct. In court, Aereo moves for a preliminary injunction, district court denies it, goes up to the 8th Circuit, the 8th Circuit affirms. 8th Circuit says there's no transmission to the public here. Aereo sends private transmissions that are available only to each subscriber. Now I'll go back to the steps that I was mentioning, and you can see how important this 1-to-1 issue is. And that's what the 8th Circuit seized upon. The Supreme Court takes certiorari, and they phrase the issue as follows. Does Aereo infringe the plaintiff's exclusive performance right by selling its subscribers a technologically complex service that allows them to watch TV programs over the internet at about the same time as the programs that are broadcast over the air? The court says yes. How does it reach to this conclusion? Well, first, it frames the issues in 2 ways. First, is there a performance here? Remember, the 106.4 statute says one of the exclusive rights is to perform, so is Aereo performing. Number two is if they are performing, do they do it publicly? Because that's the other part of the statute. Let's take the first issue. Does Aereo perform? Aereo says, no, we don't perform. All we are is a supplier of equipment that operates as an antenna for a residential user or a DVR. They're a rental company, and they're renting their antenna and their hard drives and their software that translates the data. That's all they are. What does the court say? The court says, well, okay, let's go back in time just a little bit. You know, in 68 and 74, we decided these cable TV company cases, and the court said, that broadcast signals publicly available can be carried by cable TV providers to home viewers without copyright liability. We don't have to get into why they said that. That's what they said. There were two cases, this fortnightly and teleprompter case. So the cable companies had a green light, fair game. But the court said, you know, in 76, Congress got a little upset with us, so they amended the act, specifically in the legislative history, to overrule the fortnightly and the teleprompter decisions. And one of the things, not only did they say they're overruling it, but they enacted the transmission clause, which is nice and broad. An entity performs publicly when it transmits a performance to the public. Well, if that's what perform means, the court says this covers cable TV systems, and now we go to Aereo. Under the amended act, Aereo's activities are substantially similar to those of the cable TV companies in fortnightly and teleprompter. So the court said, look, whatever Oz is doing behind the curtain doesn't really matter to us. All we know is that it's performing within the cable TV amendment that Congress enacted, so there's a performance. Aereo is not just an equipment supplier, Aereo performs. So they answered the first question, there's a performance. What about the second question? Did they perform publicly? Aereo says, no, we got a stronger argument there. Look, each antenna is dedicated to a single subscriber. Aereo makes a single personal copy of the show. Aereo transmits that copy only to a single subscriber, and only that subscriber can see it and hear it. They have a password and so on. So this is a specific transaction between a single piece of hardware and software at Aereo and a single subscriber. There is no transmission to the public. What does the court say? And this is where I think the court gets a little sloppy, but this is its reasoning. Look, that may be well and good, but there's no difference from the viewing experience between what you're doing and what the cable TV companies did that Congress tried to sweep into the act. And there's also no difference in the commercial objectives between Aereo and the cable TV companies. So for all our intents and purposes, whatever you do behind the scenes, the technical wizardry is irrelevant. So to me, the court is really getting at some larger issues of the copyright law and not really getting into the nitty-gritty of the technology. And as they say, now they're looking at it from the standpoint of the viewer, why would a subscriber who wishes to watch a show care whether she receives it via a large multi-scriber antenna, that is cable, or one small dedicated antenna, which is Aereo? It's no different. Now, what about publicly? How public is it? Well, the court says if you transmit a show to multiple people, regardless of the number of discrete transmissions, that's transmission to the public. And it gives these analogies. I can send 100 identical emails, each to one recipient, or I can send one email to 100 recipients. It's the same. The latter is clearly a public transmission. It's no different from the first. Or if I'm running for public office, I can leave 100 identical voicemail messages, each to one person's home, or I can go into a public square and give a speech to 100 people, which would clearly be a public transmission. They're both public speeches. So we have a large number of, these were the criteria. We have a large number of people, they're unrelated to one another, they're unknown to one another, and they're outside of the normal circle of family and friends. If that's what you're doing, you're making a public transmission, and that's what Aereo was doing. So the summary, the majority summary, in my view, is captured in these little quotes. It says, Aereo systems are highly similar to those of the cable TV systems in the two cases, fortnightly and teleprompter. Those are the activities that the 76 amendments sought to bring within the act. And any differences concern not the nature of the service, but the technological manner, and the court isn't concerned about that as far as copyright law goes. So, victory for the plaintiffs. There was a dissent, as you might imagine, and Justice Scalia authors it, and he says Aereo does not perform. And here's his point. His point is Aereo doesn't choose what content gets transmitted. It's the subscriber that's doing the work here. and we're going to get back to that in a minute. Aereo does nothing more than operate an automated user control system. So he's looking at the acts being undertaken on the part of the user. And why does he do this? He says, well, there's no volitional act, and to have direct liability for copyright infringement requires a volitional act. It's the subscribers who call all the shots by choosing the programs to be streamed, to be copied and streamed. It's not Aereo. And this is not enough for direct infringement. And importantly, now there was an allegation of secondary liability in the case, but that wasn't the issue before the court on this particular case. And I think Scalia is struggling a little bit to deal with it, and here's what he says. He goes, I share the court's evident feeling that what Aereo is doing to the network's copyrighted programming ought not to be allowed, but perhaps we need not distort the Copyright Act to forbid it. As discussed at the outset, Aereo's secondary liability for performance infringement is yet to be determined. So all he's saying is, look, you can't use the Copyright Act to sweep in a direct infringement claim where there's no volitional act by Aereo. What does the majority say? Again, it's a technological difference from the cable system that's invisible to the subscriber and the broadcaster. This is cable TV updated to the 21st century. That's the court's view. What does he say? In one of these lovely phrases that only Scalia can come up with, he says, this is guilt by resemblance. Which you got to give it to him. He knows what he's doing. That ignores the differences between cable TV and what Aereo is doing, and he points them out. He's saying, look, the cable TV model years ago, it was a massive push. All broadcasts were pushed to all subscribers at all times, and it was the cable TV companies that were doing all the acting. Here, Aereo transmits specific signals to specific subscribers at specific times selected by those subscribers. Those volitional acts that would give rise to direct infringement come from the subscribers, not Aereo. So the technical arguments that Scalia is raising, completely unmoved to the court. The court is looking to the viewing experience of the subscribers and the commercial objective. And that's where this case stands. And does it have a broader meaning? It seems to me that if the majority of this court, has another copyright case, we're going to see the same kind of thing. They're just not going to be very interested in getting into the nitty-gritty of the technology. They're going to look to the higher purposes of the copyright law. Okay, so that case was decided. I'm now going to move on to a case that is going to be decided in the trademark field, B&B Hardware v. Hargis. This case actually has a lot of, in my view, very real-world implications regardless of your business. If you have any trademark-related matters, I think it's going to have some impact. All right, B&B is the plaintiff here. They own a federal trademark registration for Seal-Tight that they use for fasteners. Hargis files an application to register Seal-Tight, spelled a little differently, for other fasteners. B&B, it survives the examination process. It goes to opposition, and B&B opposes. Now, for those of you that don't know, very quickly, if you survive the substantive examination process in the Patent and Trademark Office, your mark gets published for opposition. Anybody in the world who feels that they would be damaged by registration of the mark can oppose your mark. An opposition is a mini lawsuit. It shares some attributes of lawsuits, but not all. The important thing is that you can oppose it and you can stop the registration if you succeed. The key finding in most oppositions is whether or not there's a likelihood of confusion. And in this case, the Trademark Trial and Appeal Board, which is the arm of the Patent and Trademark Office that handles these things, they find, yes, there is a likelihood of confusion, so they refuse to issue a registration to Hargis. Okay? Hargis, though, had been using the mark, and they said, well, okay, we don't get our registration, we're going to continue using the mark in the marketplace. B&B files an infringement suit, goes to trial, and the jury finds, contrary to what the board found, that there is no likelihood of confusion. Now, in the course of the case, B&B Hardware asked for summary judgment of the court to say, look, we already know what the Trademark Office said. They said there's a likelihood of confusion, preclusive effect. They can't challenge us via collateral estoppel. The district court said no, and the Eighth Circuit likewise said no, and they affirmed the jury's verdict. B&B files petition for certiorari, says there's a four-way split. It's a mess among the circuits about what they do with these board decisions that on certain issues, courts don't know if they're supposed to find preclusive effect or not. There's four different options. Some courts say yes, collateral estoppel. Some courts say collateral estoppel, maybe, depends on what the factual findings were at the board. Some courts say no collateral estoppel, but we're going to give it deference. And the Eighth Circuit now has said no estoppel, no deference. So please take the case. And the court did take the case.
to my surprise. By the way, they solicited the view of the Solicitor General, who gave the most ambivalent, qualified reasons to take the case I've ever read, saying it wasn't the right vehicle and this doesn't happen often, but the court took the case, which I think was surprising to many of us in the bar. These are the two issues that the court's going to grant certiorari on, or decide in this case. Whether a finding by the board on a likelihood of confusion precludes Hargis, in this case the defendant, from relitigating that issue in infringement litigation in which likelihood of confusion is an element. And if not, is a district court obliged to give deference to that finding? So I don't know which way the court's going to go, but I do think it's important to point out what I know the issues are going to be by both sides. Here's just a brief explanation of what the differences are between these two forms and the similarities, and why it's going to impact the court's decision. We have two different tribunals here. The Trademark Trial Appeal Board is an administrative agency. Lawsuits are brought in front of Article III courts. I've literally been in front of an Article III judge who said, I'm not paying attention to what some administrative agency is telling me. That's one view that might hold. On the other hand, there are cases in the Supreme Court that talk about, under the APA, preclusive effect to administrative agency decisions, not in the PTO context, though. The legal analysis is quite different. In the Trademark Trial and Appeal Board, it's a very cold record. It's what's the mark and what's the goods in the registration, and then it's what's the mark and what's the goods in the application. And they compare the two. Now, some boards, some panels go a little further and they get into the marketplace, but not all the time. Sometimes they simply look at what's on the cold record. In court, it's a very different world. You absolutely get into the marketplace conditions, consumers, sophistication, all sorts of things that impact the real world use of these marks. And that, in fact, is one of the arguments that Hargis is making, that the board didn't consider any of those things, whereas the court did. The Lanham Act sections are different, as you can see here. The relief is different. In the board, the only thing the board can do is tell you whether or not you're going to get a registration. It can't issue an injunction, it can't give you money damages, it can't give you attorney's fees, it can't give you costs, it can't do any of that. All it says is yes or no to the registration. A court obviously can do all those things and more, so the relief is different. And finally, there's a difference in the burden of proofs, because at the board level, doubts run in favor of the plaintiff, who is the registrant, whereas in court, it's always the burden of proof is on the plaintiff. So these are very interesting differences that we as trademark lawyers have to balance all the time. I don't know how the court's going to come out, but these are going to be the decision points that the court's going to deal with. What does this mean to everybody? Here's what I think it means and why I was a little surprised. Well, I think it's going to have some impact. Very often what happens is a client will come to us and ask to file a trademark application, and we do so, and they survive the examination process, and then they get opposed. And they say, well, how much is it going to cost? And we'll say, it costs more than you think it's going to cost. But if you've been using the mark for a long time, look, just get rid of the application and continue using the mark. You've been using it for X years without complaint from these people. Just continue, go on your merry way. And 9 times out of 10, that's what happens. And the reason we've been telling that is because if a lawsuit later comes, it's not really clear that there'd be any preclusive effect, okay? Now, though, if it turns out that the court says collateral estoppel effect, that changes the equation. The advice is, well, you can get rid of your application. It's cheaper that way. The problem is, if they sue you, you may not be able to contest the likelihood of confusion. That's quite a cost. The other related cost is if you're in the opposition. These oppositions, they teeter along. They're not quite as aggressive and fast and as expensive as lawsuits. But if the cost now, if the ripple effect is that you may have collateral estoppel effect, they may amp up the aggressiveness of oppositions because much, much more is at stake here. So the trademark bar unquestionably has its eye on these things. It was not quite the automatic that it has been up until now to simply abandon the application to get rid of the opposition. The court may say you're going to pay a heavy cost in litigation. So the bar has its eye on it. So that's coming down the pike. That's my presentation. I hope it's been informative. I'm going to turn it over to my colleague, Josh Frick, who's going to talk about IP issues in social media.
Okay, as John mentioned, I'm going to talk about common IP issues in social media, photos, posts, and platforms, IP issues in social media. Wrong way. Before I get into the substance of the presentation, I thought it'd be a good idea just to go over a high-level summary of the IP issues that you're likely to encounter when you're working with social media. Breaks down in 3 different areas. The first one is copyright, which is the right to control original creative works of authorship. And a big thing to remember when you're working with copyright, whether it be in the social media context or any other context, is do you have the right to use the work the way you intend to use it? Another big issue in social media is trademarks. It comes up a lot in the social media context, and this would cover brands, logos, word marks, taglines, essentially anything that would indicate the source of your goods or services. And a big consideration when you're dealing with trademarks in the social media context is your social media post consistent with your company's culture and the brand? You don't want to make a post on the social media platform that's going to undermine the goodwill that you've built up in your brand. And the last big area of IP that's at issue in social media is the rights of publicity and privacy. This includes the rights of people regarding the use of their image, their voice, or any other identifying attribute, usually in a commercial context. And this usually comes up when a celebrity is at issue, if you would reference a celebrity in your social media post, if you would use a picture of a celebrity in a social media post, and also is there an endorsement at issue. This, again, usually pops up with the use of a celebrity, but it can also come up with non-celebrities as well. And why is all this important to keep in mind? Because you should keep not only your own IP rights in mind when you're working on social media, but keeping all this in mind and working through things properly helps you avoid infringement claims, which corporations are targets for infringement, and to avoid any infringement claims, you should monitor not only what your company is posting to the company's social media platforms, but also monitoring what people are actually posting on your Facebook page, or maybe tweets that go out to your company, things like that. So that brings us to the next topic here, which is user-generated content, which is solicited or unsolicited. This is content that you don't necessarily post to your platform, but it could be comments, like I said, comments on your Facebook page, or it could be reviews on your website, things of that nature. So the first type of user-generated content is solicited user content, and it can be good or bad. And by solicited user content, I mean companies like to engage their fans, they like to engage their customers, they want to get people involved with their social media platforms, so they actually go out and they ask people, send us reviews of our products, make comments about how much you like our products, send us pictures of you using our products, anything that they think will help promote their brand. And this can go very well for a company, or it can go south pretty quick, as we'll see. So this first example here from Domino's is actually a good what I'll call a transformative use of a consumer review. So they ask people to give reviews of their product, reviews of their pizza. So this review here from a Twitter user, CoolKidEddie21, says, referencing the Domino's pizza, "It's so beautiful close up." So Domino's took this tweet, put it on front of a close-up picture of their pizza, and put it on their Facebook page. It's good, free advertisement for their product. I mean, it's an actual endorsement from one of their fans saying how beautiful the pizza is. This is a good use of a solicited comment from one of their customers. Now, before doing something like this, it's important to get consent from the social media user. So hopefully Domino's got consent from this CoolKidEddie21, and you can either get consent before they post by having people acknowledge that any post that they make to your social media platform, you're going to be able to use promotionally, or you can contact people after the fact and ask them to use whatever content they're sending your way in a promotional manner. And it's also important to remember not to change the intent or the message of the social media post. You don't want to take it out of context and make it seem like it means one thing when that's not what the user intended. So this is, again, a good example of use of solicited content. This next example from the Redskins is example of solicited content that didn't go so well. Now, the Redskins sent out a tweet. They said, "Tweet Senator Harry Reid, who's a very vocal opponent of the use of the Redskins name." They sent out a tweet saying, "Show your Redskins pride and tell Senator Reid what the team means to you." Now, it wasn't surprising to me. I don't know if they thought this out thoroughly, but they received a lot of negative comments in response to this tweet. So, for example, Again, in response to the question or to the comment, tell Senator Reid what the team means to you. One of the comments was, well, it means 300 years of institutional racism and genocide. Another comment was, what does it mean to you? It's about normalizing overt racism in the 21st century. Did I do this right? Sarcastic comment. So this is, I think this shows two things. It shows that you need to think about what kind of comments are you going to get when you ask for people to comment on whatever you're tweeting about, whether it be reviews or something like this. I find it hard to believe that the Redskins marketing department didn't think something like this was coming. It also is something to keep in mind as I go through this is you have to be careful what you ask for. So another type of solicited user-generated content are contests and promotions. So instead of just asking people to send you comments, whether it be reviews or comments about your goods or services or your company, companies like to go a step further and actually incentivize your participation in their social media platforms. And it's not as easy as just sending out a tweet saying, who wants a free iPad, send us a comment on our product. A successful social media contest or promotion requires a lot of planning, and again, you have to be careful what you ask for. So this first example of a contest from Quiznos, Quiznos sent out through their various social media platforms, they asked for their customers to send them homemade commercials showing Quiznos sub, their sandwiches, superior to Subway sandwiches. Quiznos even set up a website, meatonmeat.com, where the users could upload the videos, again showing why the Quiznos sandwiches are superior to Subway, and they offered a $10,000 award for the best video. And give it to the Quiznos customers. They were pretty creative. There was one homemade commercial where it showed a man running through town looking for something to eat, and he passes up Subway store after Subway store, and he finally comes to a Quiznos store and pops in and with a sigh of relief orders a sandwich. Another one was a woman's coming home with dinner for her family, and it's Quiznos in a bag, and then she pulls out a Subway bag, pulls out the Subway sandwich, and gives it to the dog for his dinner. So not surprisingly, Subway was not happy with this, promptly sued Quiznos and claimed that the homemade commercials contained literally false statements and portrayed Subway in a disparaging light. It was basically a false advertising claim. Now, Quiznos tried to get off the hook, and they pushed the blame back onto their consumers and said, well, we didn't make these videos. We're not liable for the content here. If there's a false statement on there in one of these videos, it's not our doing. Quiznos filed for summary judgment. They lost. The parties ended up settling, and the meatonmeat.com website promptly came down along with all the videos. So this is an example of you have to think through what a contest is going to get you. I mean, you ask for reviews comparing your product against somebody else, you're going to get something that the other people aren't going to like. Now this next example is an example of a contest that went a little better for the company. Pizza Hut asked for their customers to send them reasons why they should receive not only a free pizza, but also a bottle of Pizza Hut perfume, as good as that smells. So that they got a lot of positive feedback both on social media and through traditional media outlets. And for example, or as an example of one of the comments they got from one of their users, I guess it's a Twitter user, he makes a comment, my girlfriend always asks me if I love her like I love pizza, can you make her dream come true? And Pizza Hut responds, we feel you, we adore smelling like pizza all day, every day, and asks him for his address, presumably to send him a free pizza and a free bottle of the perfume, hopefully making him a happy man. So this is an example, and I think the big difference here, this went well for them. They got a lot of good publicity, and what the difference here is they were asking for positive comments about their own products. They weren't inviting criticisms of a competitor. They weren't inviting people to make things up, make literally false statements and portray the competitor in a disparaging light. So this is a good example of use of a social media contest or promotion. So just a few quick tips for these solicited type comments, whether it be a contest or just a simple review. Consider the potential for negative comments. This is something that Redskins seemingly didn't do. Another quick tip is consider parameters for when people post things. So direct their message like Pizza Hut did. Make sure or incentivize them to make a positive comment about you rather than a negative comment about one of your competitors. Also, another parameter could be tell them not to use third-party IP. So in the video, for the videos that Quiznos requested, it would be a good idea to tell them not to use other people's copyrighted music or clips from a video in their homemade commercials. And then once the solicited content's up, make sure that you review it for improper use of IP, review it for the accuracy of the claims, and also review it for competitive information. Going back to the Quiznos example, see what they're saying about the competitor, make sure it's accurate. It's also important, if you intend on using the solicited content for your own promotional purposes, it's important to ask for consent to do that, whether it be consent to use it immediately or use it sometime in the future. It's always a good idea to get consent that covers use of it now or 5 years down the road, because sometimes companies like to go back and use old promotional materials. Another example of user-generated content is unsolicited user content, and this usually comes in the form of negative comments. So this picture here is of a young girl that was attacked by dogs and it required several surgeries to repair the damage to her face. And this picture appeared with, it's a little hard to see on the screen here, but there's a Facebook post on the top from this little girl's grandma claiming that they were kicked out of a KFC restaurant because the girl's face was scaring the customers. And this, expectedly, it received a lot of bad press. How could a KFC employee treat somebody like this, especially a little girl with medical issues? And KFC, to their own credit, jumped on the issue right away. I mean, they apologized. They said they were investigating the situation. They approached this in a good way. They even offered to donate $30,000 to help the girls with the girls' medical bills. So this is an example of a good way to respond to negative comments that pop up on your social media platforms. Just as a side, unfortunately, the claim from the grandmother was untrue. They were not kicked out of a KFC store. But KFC decided to honor their offer to donate the $30,000 for the girls' medical expenses. So what does this teach us about negative comments? You should be proactive. You should set up a system to monitor the comments on your own Facebook or on your own social media platform. See what's going on out there. If there's a negative comment, respond to it quickly and respectfully. Also consider contacting the person privately. So you don't want to air out your entire conversation with this person who's obviously not happy with your product or your company. You don't want to air that out in front of the entire world to see. And also check with legal with other questions, including whether or not you should even contact this person to begin with. Now, another social media issue with dealing with IP is the unintended endorsement, which is creating the misimpression of a celebrity endorsement. Example of this that you may remember from earlier this year is when the World Series champions, the Boston Red Sox, went to the White House, as the World Series champions do every year. The Boston slugger David Ortiz pulled out his phone, took a selfie of himself with President Obama, and tweeted it to all his followers. Now that seems harmless. But soon after that, Samsung retweeted the picture of Ortiz and Obama to all of its followers and said it's quite an honor for the selfie. Now, what complicates this is that Ortiz is actually a Samsung spokesperson. He's their MLB social media insider. So while the selfie with Ortiz and Obama may be harmless, the fact that Samsung is using the same picture with the president's image in the picture to promote the product, or I should step back, the phone that Ortiz used to take the selfie was a Samsung Galaxy phone. So essentially, Samsung was using the president's image to promote its Samsung Galaxy phone. Now, Ortiz denied this was a marketing stunt, which, whether true or not, the White House was not happy with this. They were, obviously Obama consented to the selfie, but the fact that Samsung picked this up and retweeted it to the entire world, the White House wasn't happy with. They were not happy with the use of the president's image to promote a product. So this is a risky example. There were no real consequences from this, but it's an example of how you can get into hot water for using a celebrity's image to promote your product, even on a social media post like this. The next example, there were a little more severe consequences. Dwayne Reed tweeted out this photo of the actress Katherine Heigl walking out of one of their stores. Dwayne Reed is a New York-based drugstore, and in case you can't read it, the tweet says, "Love a quick Dwayne Reed run. Even Katie Heigl can't resist shopping at NYC's favorite drugstore." So they're saying how much she likes shopping at the drugstore. Katherine Heigl didn't like this. She sued them for $6 million, said that they used her image and her name to promote their product without her consent, and not to mention the fact that she wasn't paid for this. Now, this may seem ridiculous, but as ridiculous as it may seem, she doesn't have that bad of a claim here. I mean, celebrities don't like to give away their names. They don't like to give away their images for free to promote products. They want to have a say in it, and they want to get paid. So the bottom line is Duane Reade used Katherine Heigl's image. They used her name, which is essentially a promotion of their product. So what it teaches us is, if you're going to reference a celebrity in a social media platform, if you're going to use a photo of them, even if it's something like this, which on the surface doesn't seem that harmless, you should get their consent. You're going to get into more trouble if you don't get their consent. Now, the last, one more issue that keeps popping up is the celebrity-sponsored tweet. This is the tweet where a celebrity, you've probably seen them, where they tweet out how much they like a product, or they're using a product at a certain time. It's not always clear whether or not they're actually endorsing the product, or they're just tweeting it out just because they're using it and thinking about it and want everybody to know about it. And it's not clear if they're paid for the I shouldn't say advertising, if they're paid for the tweet. It's not clear to the general consuming public what's going on here. And to help address that and help companies avoid confusion and help companies avoid misleading consumers, the FTC has actually issued guidelines that help people, or helps advertisers avoid that type of confusion. They've told advertisers that if an endorsement is going to, if the celebrity is going to say that they've used the product, they need to have actually used the product. If they're going to make a claim about the product that needs support, the celebrity should actually have support that backs up that claim. And also, I think, and most importantly, especially in the context of these tweets, if the celebrity is going to make a comment and there's a connection between the celebrity and the company, or the celebrity and the product that would affect the consumer's view of how they view this comment, such as the celebrity is getting paid to make this statement, that needs to be disclosed. So we'll take a quick look at some of these celebrity-sponsored tweets that have popped up recently, and evaluate them under that FTC guideline, looking at those with that in the background. So this one on the left here is from Kim Kardashian. She tweets out, "Pregnancy lips at EOS to the rescue." Now, I didn't know this, but EOS is actually a lip balm, and she's saying that it's helping her with her pregnancy lips. Whether or not she just likes the EOS lip balm that much and she wants everybody to know, call me cynical, but I think this is probably an endorsement that she's probably receiving some sort of compensation for. But you can't tell by looking at this, and that's the issue. I mean, I think she has over like 17 million followers. Are her followers going to look at this and think that she likes it and go buy it just because she likes it? Or would their view of this change if they knew that she was getting paid to make this tweet? Same thing with Justin Bieber's tweet on the right here. He says, "Everybody knows I love my mom at 1-800-Flowers. Mother's Day's on Sunday." Now, he may actually love his mom, and he may have actually sent her flowers, but the reference to 1-800-Flowers, that seems like an endorsement or an advertisement for their services. And again, by looking at this, it's not clear on the face that that's what's going on. And that's what the FTC is trying to avoid. And the last example down here is from Deborah Messing. And she says, "Thankful for the first day of spring, but believe this allergy sufferer has Zyrtec ready." And it says #ad. Now that's the important part of this tweet from Deborah Messing, is the #ad. This is something that the FTC is actually trying to encourage advertisers to use. If they have a relationship with a celebrity or anybody else that's endorsing their product, they want them to use this little hashtag at the end to indicate to consumers that this is actually an ad, that Deborah Messing is being compensated for this tweet. Whether or not that catches on, I don't know. It may be dependent on whether or not the FTC decides to crack down on advertisers and celebrities for making the type of tweets that Justin Bieber and Kim Kardashian do here, where you can't tell whether or not that it's an advertisement for the product. So that it's something to keep in mind when you're if you decide to engage a celebrity to make a tweet, make sure that they make it clear that they're being compensated for this, so there's no confusion out there in the marketplace. Those are the big issues. Back up. Those are some of the big issues in social media, and it's, I guess, the lessons that we bring away from this is it's important to monitor what your company is doing on social media, and it's also important to monitor what other people are posting to your social media platforms, because both of them can get you into hot water, and it's important to think about how things are going to play out when you send something out to the internet, to the rest of the world, because you never know. But it's good to plan that and avoid a situation like the Redskins situation where you get a bunch of negative feedback. So now I will turn it over to Aaron Wright-Lawson for 2014 Supreme Court false advertising cases.
Well, thank you, everyone. I'm going to wrap up with a review of false advertising cases, so we might as well get started so we can enjoy our meal. We're going to talk about two cases this evening. The first is the Lexmark case, and the second is Palm Wonderful, which you may be familiar with. Jumping into Lexmark, many of you may be familiar. Lexmark offers printer toner cartridges and ink cartridges. I personally have one at home. This is a picture of what their toner cartridge looks like. And as you can imagine, the Lexmark branded cartridges are expensive. So enter the market of remanufacturers who will refurbish your empty cartridge at a cheaper cost, fill it up, pop it in your machine, you're ready to print. Naturally, Lexmark isn't very happy about this, so Lexmark develops a prebate program. And what they're trying to do is incentivize customers to return empty cartridges directly to Lexmark so they can refill them at Lexmark and distribute them back in the market. They do this by offering a discount so customers get a cheaper price on the front end, and then they give them a prepaid mailing package to mail the cartridge back to Lexmark. What Lexmark does to be creative, though, is that they embed a microchip into their cartridges. And what happens is when the cartridge becomes empty, the microchip turns off. And whether that cartridge is refilled or not, and you put it back into your machine, the microchip prevents the cartridge from working again, unless Lexmark will replace that microchip. So, as you can imagine, enter Static Control. Static Control develops a microchip that mimics or imitates Lexmark's microchip. And what's important here is that Static Control is not competing directly with Lexmark. All Static Control is doing is creating these little microchips and selling them to remanufacturers who then go on to refill the toner, replace the microchip, and off they go back into the market. So Lexmark isn't very happy because it's undercutting from Lexmark's business. So Lexmark sends two communications out into the marketplace. The first thing it does is tell customers Lexmark toner cartridges need to come back to Lexmark. The second thing that they do is send a communication to refurbishers. And here, this is a strong communication because they're telling refurbishers that it's illegal to use Static Control's microchips. Well, what does Static Control do? They file a lawsuit. They filed their lawsuit at the end of 2002. So believe it or not, this case has been, the litigation of all litigations, it's been pending for 12 years. But at the inception in their pleading, they brought a false advertising case. And they basically said, hey, we're losing sales and this is harming our business reputation. Well, the district court throws the lawsuit out. And basically they throw the suit out claiming that Static Control doesn't have standing to bring the suit. They find that on the basis that Static Control's injury is too remote and it's not a direct plaintiff. Well, the case is appealed and it goes to the Sixth Circuit. The Sixth Circuit reverses and finds that in fact Static Control had a reasonable basis that it was for believing that its interests will be harmed and that it has a reasonable interest that it's trying to protect. The Supreme Court granted cert at the end of 2013 because there was a circuit split. And the way that the circuits came out is that there were varying tests that were being applied. The issue that the court was looking at was what is the appropriate analytical framework to determine a party's standing to maintain an action for false advertising under the Lanham Act. First, the court started with the statutory language of Section 43A. And the key thing here is that the statute itself tells us any person who believes that they're likely to be damaged can bring a suit. Well, so far so good for static control. The trouble here, though, is that that's awfully broad, and under the bare language of the statute, presumably anyone could have standing. So the Supreme Court says, well, we need some reasonable limitations. So what are those limitations? Well, the court says that to be a plaintiff in a false ad case, you need to fall within the zone of interest protected by the Lanham Act. And what that means is that a false advertising plaintiff must either allege an injury to your commercial reputation or injury to sales. Once you get over alleging that you have a proper injury, your injury must be proximately caused by the false advertising or by the deceptive statement. So here, this proximate cause element gets to weeding out claims that are too remote. So based on the proximate cause element, if you are forced out of business based on a false advertising, that claim would be actionable. Compare that to a competitor's landlord who ends up losing money because the competitor can't pay their rent. In that case, that would be too remote. So here you have a false advertising plaintiff must show, again, economic injury or harm to reputation. And how do you do that? What do plaintiffs need to plead? Well, at the end of the day, plaintiffs need to prove that, or at least allege, that the deception causes consumers to withhold trade from the plaintiff, right? So consumers stop spending money. The court ultimately has a narrow holding, which this is the test that's going to live on in infamy. And it says that to invoke the Lanham Act's cause of action for false advertising, you must prove an injury to a commercial interest in sale or business reputation that is proximately caused by the defendant's ad. More importantly, in this case, after 12 years of ongoing litigation, Static Control adequately pled that the elements of this claim and can proceed with its false advertising case. So the takeaway of this is that false advertising plaintiffs are no longer limited to direct head-to-head competitors. However, if you are not directly competing with the defendant, you may have a harder time. You may have an uphill battle. Stepping back and looking at the bigger picture, out of the Supreme Court cases that came out last year, this is the case that will probably be in all of the case books for years to come. This has been called the tour de force on standing law. And what's notable about this is that the Supreme Court assessed a variety of circuit approaches and threw them all out, which is highly unusual for the Supreme Court. It also rejected its previous law and position on standing, which is also very unique, that it basically said prior courts were wrong and this is the appropriate test. And finally, to note, because of the proximate cause element, it may be more difficult to prove standing, but now we have clarity and this test will be applied uniformly. Okay, turning now to Palm Wonderful. This case made a lot of news because of the ingredients in this product. Minute Maid offered and continues to offer a blueberry pomegranate juice blend, which you see here. Zooming in on the label, you can see it clearly says in all capital letters, pomegranate and blueberry separated on two lines. You can see in the image here we have an open pomegranate, we have blueberries, plus an apple and some raspberries, leading consumers to believe that this is blueberry and pomegranate juice. Well, what do you think is in the juice? 0.3% of pomegranate juice and 0.2% of blueberry juice. Yeah, I know, shocking, isn't it? It's not what the label says. So it consists of predominantly less expensive juices, right? Because Minute Maid is mass manufacturing. Well, Palm Wonderful sues, because if any of you are familiar with the Palm Wonderful product, it is pomegranate juice. They're the largest grower of pomegranates, and they claim that this is false advertising and that their sales are being hurt by these labels. Well, the district court and the Ninth Circuit say that Palm Wonderful's claims were precluded by the Food, Drug, and Cosmetics Act, which forbids misbranding of food through false advertising. So the Supreme Court grants cert to address the issue of whether a private party can bring a Lanham Act claim challenging a food label that's regulated by the FDCA. And the answer, the Supreme Court says, is yes. For Palm Wonderful, this is a very straightforward false ad claim. However, Coca-Cola argued that the FDA can bring any enforcement action against companies whose labels do not comply with the FDCA. So because the FDA can take enforcement action, that the Lanham Act claim is precluded because there is another remedy, and it happens to be a remedy through the FDA. However, the Supreme Court says exactly the opposite. The Supreme Court finds that the Lanham Act claim and the FDCA are actually complementary. And they start by looking at the text of the statute, and neither statute expressly says that one claim is precluded by the other. So here we have Congress acting, passing laws that, that this was not contemplated. More importantly, these statutes have been living together in harmony for 70 years, and that is, without congressional action. So clearly, Congress did not intend for one to preclude the other. Also important, they have different purposes. Lanham Act protects commercial interests from unfair competition. FDCA protects public health. Finally, different enforcement means. Lanham Act is private enforcement between competitors, naturally must have standing and satisfy Lexmark, whereas the FDCA is enforcement by the government. The government comes in and offers or argues partial preclusion, which this is a very interesting argument. So the government steps in and says, well, you can bring Lanham Act claims if you're going to challenge the name of the product on the label, but if you're going to challenge any other aspect of the label, that is precluded by the FDCA. And the court says, not so fast. You're not able to reorder federal statutory rights. So the takeaway on this is that if a false ad Lanham Act claim challenge to a label is not precluded by the FDCA. What's interesting about this is that this has far wider implications than just juice labels. It's very likely that other products are going to be implicated. It certainly means that food and beverage companies that comply with FDA regulations are not necessarily safe from false advertising claims. And essentially, the FDCA now has become a floor, but is by no means a ceiling. So I think to net it out, together with Lexmark, I think it's almost certain that we're going to see a significant uptick in false ad claims by competitors. And one recommendation certainly would be to audit your ads for misleading content. That was awfully fast by me, so I guess we'll take questions.
Yes. Thank you, Aaron, and thank you, Josh. And we do have a microphone in the room for anybody that may have questions of any of us. I would just ask that you speak clearly. We are taping this, and we'd be happy to answer any questions, either on the topics or otherwise. We'll do our best. No? Okay, well, we will all be here for a little bit after, so that if a question pops up, feel free to corner us. I'd like to thank everybody for coming. We'd like to thank the ACC as always. They're wonderful to work with. We enjoy coming here and presenting this. Aaron, thank you very much for taking time from Groupon. And Josh, very well done. We have a raffle. Make sure you drop your business card in the bowl up front to win a football signed by Mike Ditka. The winner will be contacted tomorrow. We'll email everybody next week to let you know who won. And the slides that we have here today are going to be emailed to everybody in case you want to peruse them. And as said at the outset, if there's anything we, Brinks, can do for you in the future, we'd be happy to do it. So thank you for coming, and enjoy the rest of the evening.